Christian. May we kindly give him a round of applause.
Good morning. Dumi, thank you for the heartwarming introduction. A master of food, that's a first, but I'll gladly take it. Ladies and gentlemen, my duty here today is to give you a context or a background of the case, so that as the participants start presenting the cases, you are able to follow and understand precisely what they're talking about. I just want to highlight in a nutshell what the issue that brought us here is. So before this honorable court, there are three parties. The first party is Isabella Amon. Isabella is a decorated Olympic swimmer. She has secured 5 gold medals at the Tokyo Olympics, and she holds the world record in the 50-meter freestyle and 100-meter butterfly. Those are swimming events. The second party is the South African Federation of Swimming. So I will refer to them as SAFS as I keep on presenting. So SAFS is the National Federation in the discipline of swimming. If you are a football fan, they are more or less your SAFA, your South African Football Association, but in this instance they are the South African Federation of Swimming, and they are established under the National Sports and Recreation Act. The third party, which will be our amicus curiae, is the Institute for Accountability in South Africa. To give you a brief background, so SAFS initially introduced some regulations that were aimed at preventing athletes with certain XY disorders from participating in swimming meets unless their testosterone levels were suppressed to a certain level. Isabella, who is the applicant, took issue with these new regulations because she felt that 1, they were discriminating, 2, they violated their rights to privacy, 3, they were an insult to swimmers, 4, they were unnecessary because they were not part of the rules of the ISF. Now, Isabella publicly criticized these regulations and would make her views felt through television and newspaper interviews. As a result of this, SAFS instituted disciplinary proceedings pursuant to Rule 8, Chapter 4 of their domestic rules, which, in a nutshell, require swimmers not to act in a manner that is damaging to the SAFS's reputation or bring the sport into disrepute, and also provides that swimmers should not publicly criticize this organization. Isabella then proceeded to secure an urgent interim interdict against these disciplinary proceedings which were instituted against her, pending a review against the SAFS. Now, in Part B of her application, she sought the following relief. Number 1, the reviewing and setting aside of the decision to bring disciplinary hearings against her, and 2, declaring that Rule 8 of Chapter 4 is unconstitutional on the grounds that it violates the right to freedom of expression. In reply, what SAFS did then it was to rely upon or invoke Rule 10 of Chapter 2 of its domestic rules. Now, in terms of this rule, the rule essentially requires that any dispute between persons or persons such as Isabella, any dispute between them and SAFS should be determined by way of arbitration and not proceed directly to court. So what it meant is that Isabella was not supposed to approach the court directly, but rather make use of the arbitration mechanisms available to her under the rules. Now, Isabella opposed the idea or this requirement of arbitration on the grounds that Rule 10 did not amount to an internal remedy, but rather constituted an ordinary arbitration clause. So my esteemed colleagues or counsel before court have a duty, and their duty is to primarily answer 7 questions. The first question is whether does Rule 10 of Chapter 2 of the South African Federation of Swimming's Domestic Rules and Regulation constitute an internal remedy for the purposes of Section 7.2 of the Promotion of Administrative Justices Act. The second question they have to answer is, do the interests of justice require this matter to be heard by way of arbitration or by way of court proceedings? The third question is it appropriate in the context of this matter for an arbitrator to preside over the dispute between the parties? 4, does the mere fact that the constitutional issues have been raised mean that the matter can only be decided in court, or is there any scope for an arbitrator to decide this matter? 5, do the rules of the SAFS infringe on the constitutional rights of swimmers? And if so, which rights are infringed? Number 6, does the right of access to court enshrined in Section 34 of the Constitution require this matter to be heard in court, or can the matter be heard by way of arbitration? And what is the appropriate relief? Now, I'm quite sure that you may have heard the phrase Section 34, access to court, as the previous speakers before me took the podium. More time and my speech was already at the end. Okay, but I'll see what I will do. Alright, so in a nutshell, you might have heard the phrases Section 34 and access to courts, right? What do we understand by this section? So in a nutshell, Section 34 provides that everyone